Hi everyone, my name is Ivan. I'm affiliate manager at Master Bundles. Our company welcomes everyone who visit our webinar today. Actually, today we are going to discuss a very important topic for every designer, every vendor who sells his design at our marketplace or any other marketplaces. So today we're going to discuss design protection action plan. And I welcome our speaker, Arsen Buchkovskyi, who's actually the master of law, the legal counsel, and he has supported creators and IT companies for more than 7 years. I guess Arsen will be able to add some more information about himself. But before this, I would like to remind everyone who joined our webinar that you have an opportunity to ask your questions during the webinar. We will have the ask and answer section by the end of the main presentation. So you can use the chat on YouTube, you can join our community on Facebook and ask your questions in the comment section below. Before we're gonna start, want to remind also everyone what is Master Bundles. Maybe you're seeing our YouTube channel and our marketplace for the first time. Master Bundles is non-exclusive marketplace where you can sell your products and mainly bundles of your design. Our main mission for every designer to provide direct support with any issues that can happen on your life cycle as a designer. Doesn't matter, it is the help with the SEO or maybe it is legal consulting. So we are going to continue the line of our webinars in future. Don't forget to subscribe on our YouTube channel to do not miss our other webinars. Don't want to hesitate you more and bother with my lyrics. So I would like to welcome our speaker, Arseny. Let me just show him. Arseny, welcome you at our webinar. Really appreciate for you attend our webinar and being our host. I guess from that moment, I can give word to you and wish everyone who visited our webinar to spend a nice time and get a lot of useful information.
Thank you. Thank you. It's a pleasure to have such a bright introduction. My name is Arsen Buchkovskyi, as Ivan said, and I'm a lawyer. Basically, I was working for a huge law company for more than 7 years, and now I'm a legal counsel and support creators, IT companies, and a lot of different other companies who create any intellectual property to protect their rights. That's pretty touchy issue. So today we're gonna talk about what is IP, like to get what we can protect and what we can actually, and what measures do any creators could take to protect his IP from stalling, from pirating, and so on. Greetings for everyone who are watching us and for those who will watch us in a record. And I guess we can start. I'm going to share my screen, so please write if you can see it properly. So yes, it is. I guess there is some okay, design and other IP protection action plan. Let's start from the beginning of what is intellectual property. Actually, there are a lot of different definitions of intellectual property because each country has its own legislation of intellectual property, and that's why it is hard to create some common view on what to do. But we are going to use several sources today. First of all it's WIPO, the World IP Organization. Second, it will be some reference to the IP course from University of Pennsylvania. And I guess I will use some Google politics to show you how to protect yourself in Google. What is intellectual property? Intellectual property actually is any creation, such as inventions, such as paintings, such as any artistic words, symbols, names, anything, any creation of human being could be an intellectual property. And all these creations are protected with different measures. Actually, there are several types of intellectual property. First of all, it is copyright. Copyright is like most common part of intellectual property. Maybe each of you saw this symbol of copyright, which indicates that some creation is copyrighted. That means that it is protected by copyright as intellectual property. Copyright is most wide part of the most wide part of intellectual property, which consists of actually everything. We'll talk about some exemption, but almost anything you can create could be protected as a copyright. The next thing is patents. I guess everyone heard about it, and the difference between copyright and patent law is in that patent is about invention. So if you invent something, you can obtain a patent for that, and then your invention will be protected not by copyright but the patent law. In most cases, the same thing could be protected or as a copyright, either as a patent. So you should, in this case, you should check what is better for you, because patent gain you the better protection mostly, but it obligate you with a lot more difficult things to do to get that protection, while copyright exists by creation. And trademark law is really separate stuff. It's really different from copyright and patents, but everyone knows what is trademark, and you can protect a trademark by obtaining a special certificate that it is your trademark. And the history of trademark is really, really great, and maybe sometime we will talk about it too. Industrial designs, which can be interesting for designers. Industrial designs protects the actually the physical or not physical, the features of some object or anything. Industrial designs, like patent, you should patent it. You should register it in separate institution in each country, and it could be like three-dimensional, two-dimensional features, and for example, some aesthetic aspect of any products, from furniture to, I don't know, to devices, electronic devices. Their designs could be protected by industrial design. Also, trade secrets and geographical indications could be an intellectual property if your product are indicated by geographical indications where it comes from. It could be it could be an intellectual property and protected by the law. So the next thing, we are going to focus on copyright as the most commonly used and most comfort for use for any creators. And the University of Pennsylvania gives us the great definition of what is copyright and what can be protected by copyright. And from this definition, I would focus on three main features of things that can be of any products, any creations which can be protected by copyright. First of all, it should be an original expression. So you need to create something to express your own ideas and fix it in some physical work or digital work, so it could be tangible for wide public. So you can obtain a copyright for your product when you express it and fix it in something, and when you can prove your authorship. And not only prove your authorship, the thing is that copyright product should have an author. And that's why, for example, now we have lots of different discussion. So could it be some creations by algorithms? Could it have copyright or not? And actually, we don't have an answer now. Some people say that algorithms couldn't create something and it should be a authorship of author of the algorithm. But there are lots of different things to discuss. And do you have something? I saw your questions, but if you don't mind, we are going to answer all questions after the main presentation. If that's okay, just write something in the comments. So the important thing to discuss is to understand what is not protected by copyright. And because it's the matter of different discussion, different complaint, so you need to understand that everything which is not have all these three indicators like original expression, fixed in a tangible medium, and has authorship is not copyright protected. For example, ideas. If you have any idea, and even if you describe it to somebody, like describe it, just talking about it or something like that, so your idea doesn't protect by copyright. Just remember it before you fix it, because before you fix it in a physical world, in any medium, it doesn't protect it, like methods, mathematical concepts, and other things that are not fixed in physical world, not created in a physical world. I mean, it can't get the copyright protection. So only products which exist in real world could be protected. That's important. Also, copyright does not protect inventions. As we said, that's for patent law. So if you create some invention, some device or chemical formula or something else, so some really new stuff, you should get a patent for that. In some cases, there are ways how to protect inventions with copyright. For example, if you describe your invention really carefully and public it, it could be protected. This description could be protected by copyright, but it depends. Your description and your invention, they are different. So sometimes you couldn't, you could protect your description, but if somebody will realize your invention in other way that it is scripted, it couldn't be protected by copyright, and that's it. Some patents, for example, in digital era, it includes software patents. They could be protected as a code in copyright matter and as a patent for how it works and so on. So sometimes you could find a way to protect your things, your inventions by copyright, but yeah, it's important to say why you need it. To get patent protection, you need to public your invention. You need to public it into special register where everyone could find it. So if you want to get any patent protection, everyone in the world actually could see what did you invent. And if you don't want to do that, I mean, if you don't want to public it, you can't get a patent. So you need to find a way to protect your invention with a copyright law. That's why it could work for both. And copyright does not protect brands. It means that trademarks usually are not protected by copyright. As you know, there are several ways to register your trademark. It could be a word, textual trademark, or it could be some pictures or so on. So if you create an original picture, it could be protected by copyright, that specific picture. But if we are talking about textual trademarks, they usually can be protected by copyright. So yeah, if you need to protect your trademark, just get a special certificate. Do not count on copyright thing. And the special theme for copyright, which need to be understood, that there is a special concept of fair use. Um, Fair use is when somebody, company or individuals can use your copyrighted products, items, whatever, um, without violation your rights. There are a really strict amount of cases where it can be, for example, for teaching, for news reporting, for criticism or something. So your things could be taken and discussing in different matter without violation. Which is the main criteria of fair use? Actually, two main criteria of fair use. First one is that if somebody takes your copyright, they need to mention you as an author. And the second thing is that this taking couldn't be the main reason of using your copyrighted stuff. I mean, if it is educational purpose of something, they are using your copyright to show some different stuff, to educate people, for criticism and commentary. That same stuff, they just create a new product by using your product too, and any other products, for example. But if the aim is to use your copyright by itself, just like show it or something without any comments, without any additional work on it, it couldn't be counted as fair use, even if it is, for example, used by educational platform or something. If it is educational platform, but it's not educational purposes for using your content, it is a violation, and you could try to protect your rights. One important thing about copyright: you have the copyright at the moment you create something, even if you don't register it. In fact, in most countries you can't register copyright. In some countries you can, but you, in any countries, doesn't depend on where you live, if you create something, you got a copyright for that. You don't have to register it, you don't have to publish it anywhere. You just need to be able to prove that you created. And create is, regarding to our previous slides, it means that you make it in physical world with some medium, digital world, it doesn't matter, but you create something and can prove that you create that in certain date and with certain steps. So, and from that moment, you obtain the copyright and you can protect your right that you create. So you don't need to register it anywhere, you don't need to show it to anyone, and so on. This huge sum, actually, $509 billion, is the estimated amount of pirated goods and services. So I think it's for 2018 from OECD report, but so now this sum is even bigger. But with this sum, you can imagine what is the market of pirated stuff, what is the market of violation, the IP rights violation. And this huge markets shows you that that's not so easy to protect your IP in modern world. And if somebody will abuse you, if somebody will steal your copyright, it is really hard to protect yourself without using suits, without using courts. But we still have some steps we can do, and we are going to talk about what you should do, first, to protect your IP rights, and secondly, if someone really stole it and you want to abuse it, you wanted to restore your rights. So the first thing is how to protect yourselves. You need to know what you have, what copyright objects, what things you have, what things you control, what things you create, which ones are copyright protected, which ones not. So that's why we were talking about this for 20 minutes. So you need to really know what copyright do you have and what copyright things can you protect. Second stuff, try to understand where you have it. I mean, if you're using different marketplaces, if you're using different stocks or something, they all have their own rights, how they take content from creators and sell it. And you should know where you have your copyrighted stuff and how the particular medium protect it. Uh, Third thing, try to record the evidence of creation. There could be different evidence. Even publication in marketplace could be an evidence. If you public it first, you could count that mostly everyone would count you the author if you were first, and no one could prove that it's not. Couldn't prove the older evidence of creation. So try to keep the source files if you can. Try to keep your first publications and so on. So if at least for most important your copyright, your IP, try to keep the evidence of creation. Timestamp your content. It connected with the previous one. If you have an evidence of creation, you should prove when it was created. For example, when you publish something in the marketplace, you got a timestamp when you publish it. For lots of different reasons, try to, for digital world, it's easier, much easier, because you have data when any file was created, but for physical world, you need to do that. So you need to write when it was created. You can make a photo, you can do different stuff, but try to stamp your content with when it was created. It is really important. The fifth, keep an eye on violations. The thing is that it's really hard to protect your copyright when you are alone and when you don't know that your copyright is violated and someone still stole your content. So there are lots of different instruments. For example, Google Alerts can help you to look through someone public your content, and there are lots of different stuff for different purposes, but try to make that kind of due diligence, that kind of audit, for example, once per month, trying to figure out, is everything okay, doesn't anybody stole my content, and so on. So try to keep an eye on that. And guard your IP. What I mean, if you saw that someone stole your IP, even if that is a little part, even if that is maybe something you wanna count as important stuff, but even in that case, anytime when you saw that someone stole your IP, try to fight with that. That won't take you much time, but the more abuse you'll send, the better different websites, domain holders, and so on will react on that. So if you protected your copyright, if you actively protected your copyright, that's better for your future when somebody will steal really important stuff. And if something bad is happen and you saw that somebody stole your IP, what to do in a digital matter? So there are first step I recommend you to do before any lawsuit or something really complicated stuff. First of all, is use the form of the service provider. I mean, if you saw your content on a different marketplace from a different author or something, lots of marketplaces, lots of service providers, they have their own abuse form, or at least they have the contact form. So use the form of provider and write immediately that you saw that your content was stolen. Second thing is to send case and disease letter, which means that you should send a letter to your abuser or to the theft you found that he's illegally used your copyright. It could be a surprise, but I know quite a lot of situations when people use your content without understanding that it's illegal. They just trying to use it, They, for example, they think that they bought it not for one time use, but for any purposes, and trying to resell it and trying to publish it and so on. So when they got when they got a letter from you that this is actually illegal thing, they could delete your content by their own. That the best thing you can face, but yeah. Third step, it use takedown notice. I wrote DMCA. That's for USA region, but actually it's so popular that they could use this acronym in different jurisdiction. So actually, takedown notice is notice not for author, not for a person who actually stole your content and public it, but for a provider of any internet services. It could be, so the first thing is the website holder. I mean, the owner of website where the content is published, but not only the website holder. In my practice, there was a situation when even for VPN provider, I mean, the person who provide the VPN services through which other persons public the violated content, even the VPN provider could help you to protect your rights. So you can found a register, you can found a domain holder, you can found anyone. Just send that DMCA. We'll talk about it a bit later, but know that it is quite important and quite widespread instrument to protect your IP rights. I mean, maybe the most important even. And first is to complain to Google. I mean, that's really a strange thing, but it works. I mean, let's talk about it a bit later. I will show you the screenshots of how to do that. So what's the difference between case and desist letter and takedown notice is that the first one is sent to publisher, I mean, to person who publish your content, and second one is send it to online service provider. As I said, it could be the owner of website, mobile app. You need to know that it's not about websites, not about like desktop versions of any content. It works the same for mobile apps, for any digital providers. Hosting provider register, that's the person who intermediate the violation, who one day or not, they are participated in your copyright, illegal use of your copyright. So all of them could be the person who protect you. So just try to send them this DMCA notice, and different providers will react in different ways. For example, website owner could just delete the illegal materials. For hosting provider could block the access to that materials. Register could make a claim to block the access for whole website. They all act differently, but if you can't get any information, any reaction from the lower branch, for example, for a website owner, then go to the next level to a hosting provider, for example. If it doesn't react, go to register and so on. Let's talk about the content of this notice. These are two different notices. I mean, case and desist letter and takedown notice by DMCA, but they are quite the same by their content. So you should sign it as a copyright owner. So, for example, if you are asking somebody for help, it doesn't mean that this person could send it for instead of you. You need to send by yourself as a copyright owner and sign it. With a digital sign, doesn't matter. Physical sign, digital sign, you can make like physical sign and scan it. You can just type your name and surname and make it like a digital sign. It doesn't matter, but sign it by yourself as a copyright owner. Identify the copyrighted work that was violated. Provide your contact information, provide a statement that you are acting in a good faith. It is important. I mean, it's just legal requirement for this kind of notices. Provide a statement that information is true and accurate, and said that you are a copyright owner, as I said before. So when you send this notice for a reputable service provider, for example, for Google, for any big Amazon, like any big store or marketplace, they will automatically delete the content you claim on. I mean, that works really automatically. They will delete the content, and then they will give the previous, like the theft, in this case, the author of the content which was deleted, they will give them 10 days to make to give the explanation, and if they do not like use that day, the content will be deleted forever. If they provide an evidence that your claim, your notice wasn't actually true, wasn't accurate, so you could get into some suit or something, but actually it is 1%, maybe 1% cases. So in most cases, the service provider, the big service provider, will just delete the content. In case of it's not a big service provider and it doesn't want to delete anything, you should go to the next level. For example, in this case, I recommend you to send a DMCA notice to Google. Google have a special form of DMCA in website supportgoogle.com. You can find, you can just click create a request, and you by this form you can delete your content from lots of Google services. For example, from Google search, and the website where your content is used will not appear in Google search. You can delete it from Google Images, Google Ad, from YouTube, and what is really important, from Google Drive. I saw how theft use Google Drive to redistribute this thing they stole. So it really works. Because, for example, for Google Ad and Google Search, it is important for different sites, and after they will be abused by you through Google, they will, in most cases, they will delete the content. Of course, there are some dark side that will not do that, because Google is not so important for them, but it's really hard to deal with them. With most sites, the abuse to Google will help you. And if it doesn't work, for example, if it's not work and the people don't react on you, on your abusing, on your claims, then try to send abuse form for the hosting provider. The big hosting providers, for example, Cloudflare, they also have their own abuse form where you can write what's wrong, and they will stop access to the website. So even if Google is not working well, the hosting provider could work. And if it's not, so you have to look through the other intermediate, the other providers that are working with that site. So you can use Whois site for that purposes, or any other sites. Actually, it's not, it doesn't matter, but you nowadays sites are not existing in some vacuum. They have lots of connection with different providers. So when you will find someone important for them, that abuse form could help you to deal even with the darkest website. Of course, it covers like 80% of cases, and 20% you can do much, except a real lawsuit, which is not a solution in this case. But for the most situations, I think that will help you. We are in master bundles. I don't know, we have published, or we are going to publish, a special algorithm for you with all these DMCA and other notices, with the forms, and where you can take it, just fill it and send it to any abuser. So use it. I think it will help you. My colleague can deliberately create it for you. So I think if it's not published yet, it is going to be published in really short time. So I hope it will help you. And now we are going to start our Q&A session, and I'm going to read the questions. hope my presentation helped you to understand what to do in this modern digital world with your copyright. So let's start from the beginning.
Arseny,
something.
I will add myself to the presentation, to the webinar, if you don't mind, and I will be glad to help you with all these questions. Also, while watching your webinar, I would like to add a couple words that we already launched the checklist, what to do if someone stole your content or design. So I believe our viewers will be able to check the link that will be added to the description after watching this webinar and use it. So everyone welcomes to follow the link, but it will be added really soon. So yes, as you said, Arsen, during the webinar we had a couple questions that will be great to cover, and let me help you. The first person who asked his question in our chat, Nikolai Klimo. So let me spell it to you. Do you have something for the website that rip off the content and sell it? They usually don't respond and the hosting providers don't care.
Yeah, that's unfortunately, that's some part of situations. I mean, for that websites, in a matter of like digital responding, we could only look for any providers who work with that websites. For example, if they indicated by Google, you can claim report to Google. If they are working with some registers, not I understand that they could use abuse protected hosters, but they couldn't use abuse protected registers in most cases. So you can claim to registers if you can figure out that they are using some specific services, for example, I don't know, for different IT infrastructure. You can abuse, you can make any claim to them. So try to widen the network of these websites and try to notice any part of this network, and that's actually the only way for today to deal with these websites. If they are stealing a huge part of content from different creators, maybe it could be a matter of lawsuit in the country where they registered, maybe. So, but anyway, you need to find out the person who stands behind that website. And for really huge stuff, it could be the solution, but for a smaller one, I don't think that anybody will try to suit with them. So yeah, try to figure out the network of the providers of that website and try to notice them about stolen content. If someone from that provider will be from USA, you'll definitely be able to stop the interaction between them. So maybe that will help you to delete that content from such websites.
Thank you, Arsen. Hope, Nikolai, we answered your questions. Arsenia answered your question. Let's jump to the next cases, next questions. Ilya Sosnyuk asked, what if someone is alleging that you have violated their intellectual property rights and are prepared to file an immediate lawsuit?
Mm-hmm. Yeah. Actually, that's a pretty common situation too, as I said before. To protect yourself, record the evidence of creation. That's an answer. If you can prove that you created the object before the person claims, I mean, the person declares that it or them do that. So just to be, you need to be first. You need to show that your creation was before there, and that will prove that you are an author. So if you don't have any, I mean, source codes or something, maybe you could use web archive or something. So there are really a lot of instruments that could show you were the first. But in each situation, it will be an individual solution. So the answer is try to how to say, defend your position. Try to say that you was the first, and that will help you.
Thank you, Arseny. Ilya also has one more question. What are the preliminary steps that usually make sense to take to protect yourself?
Yeah, actually, I
Mhm.
show them right now.
Yep.
So try to audit your IP, know what you have and where you have it, know how you sell it. I mean, what terms and conditions of your license agreements with your marketplaces or whatever you use. Um, Timestamp your content, keep an evidence that you created, and react on violations. If you sign violations, do not ignore it. Try to react in any way you can. I mean, send the DMCA. You will get that checklist with the standard form of notifications. So just fill it and send it. It will take 5 minutes, but it really could help in the future when something will begin.
Also, web design library ask, I guess, a huge real case. Let me read it for you. Unfortunately, there are many stores who stole my design, resold them, and reported them to Etsy, but there is no answer. Also, a while I found one with a large page that sends my design to clients for free so that she gets visits to her site. And when she sent her a message, she said that it is her right because she has a commercial specialty. Many customers have a misunderstanding of the commercial license. What should I do in this case?
Let's divide it into a few questions. So first one about stalling the designs and how to say, selling them with Etsy. Etsy really cares about IP. I worked with them several times. So if you make a DMCA notice for Etsy, they will react. So just use our forum, try to prove your authorship, try to prove that your content is violated, your IP rights is violated, was violated. So Etsy will help you. I mean, definitely. Maybe they could like lost the first one, but make a few, and they will help you. In case when you contacted with person and she said that she bought design and can use it in commerce, you need to figure out the whole situation, where she bought it, what terms was when she bought it. Because for example, when we are talking about master bundles, we had that terms for vendors, for clients, and you can refer to a special policy and show that it's like one-time use, or it's like 20-time use, depends on the license. So just show the license. And if she won't react on that, if you can't prove them, if she will ignore you or something, first contact Google, because if she want to create traffic to her website, I think it's important for her to have a good Google account with Google Ads and Google Search. So report to Google, and it will help you in the dialogue with her. And second, report to her register and hoster. So if she cares about her website, it will be important for her. So you could protect your rights using DMCA abuse to these three vendors of services for her. Yeah.
I also wanted to add a couple words to this case as well. Everyone who's watching that webinar, if you work with master bundles, you are very welcome to contact our managers, our emails, our community. If you unfortunately happen in this situation, and our managers with the big pleasant will be glad to help you with these cases. Then let's continue with our questions. Nastya Zelenovskaya asks, is there a difference between US and UK intellectual property laws? Do intellectual property laws work in Russia?
First of all, about difference, there is difference between intellectual property law in any countries. Yeah, it is a big difference. I can't say it is big because it's different in different matters. For example, between US and UK intellectual property, uh, there is a big difference in the matter of employment. And where you employ somebody, he or she creates something, who is the owner of that. So there are quite a big differences, but quite a lot of differences. But in the matter of what we are talking about, there are, I guess, no huge differences. So even, yeah, DMCA is a truly American thing. I mean, DMCA is the US law, and service providers should obtain it if they are working in US. But in UK, there are quite similar rules. So yeah, you can't name it DMCA, but it is still a notice, takedown notice by other laws. So no, all the things we were talking about is universal for any country. For example, in Russia, yeah, there is the things like DMCA, and yeah, they don't work really well. But the thing is that we live in a really globalized world, and the people and people and organizations who work in Russia, they are usually work in other countries too. So they are trying to obey the international practice. And I know quite a lot Russians hosters who react on DMCA, even if they do not obligated to do that. They react carefully because they know that if they will start working in US market, they could be asked about the violations in the past. So in modern world, big companies, big holders are trying to go with the international laws and international best practices. So yeah, in this case, Russian works the same as any other countries. But yeah, you can't use you can, but it isn't so effective to use local laws to protect yourself.
Here's one more question from Nastya, but I believe it is a second part of the previous question. So let's make a short conclusion. Nastya adds, how designers can protect their works from burglars from countries where there are no intellectual property laws?
Yeah, I was trying to answer this for the big part of webinar. Actually, try to find try to find service provider for such a website who works with USA or is quite big to react on your forms. Yeah, the website owner could be less interested in obtaining the US rules or like international best practices, but you can always find someone in that chain of supplying digital services for this particular website who are interested in obtaining that international rules. For example, if the site is on Amazon Web Services, if the site use Google Ads or Facebook Ads or anything globally spread. So try to go through that door and try to notice them that this site violated the IP rights. So it could help really.
Thank you, Arseny. And here, I guess, the best moment for me to ask the question that I prepared by myself. Especially that's because many our vendors, when I work with them, when we chat about their works, they have one similar question: what's the difference between reference and plagiarism?
Mm-hmm. Yeah, I was trying to answer this question when I was talking about fair use. Reference is fair use. If that's me, it means that someone creates some content. For example, they want to compare some styles or something. So they create a new work and to refer to your work to show something, to prove the ideas, to criticize you, maybe that's okay. To parody you, that's okay. So the reference is for use when they name you, when they show that, yeah, that's his or her content, and I'm using it for special purpose, for my own purposes, for creation my own object of intellectual property. That's the fair use, that the reference. The plagiat is when someone just stole your content and said that it's his or her content without mention you, or even if they mention you, but they just sell your content without any adoption, without any working on it. So that's plagiat.
And one more question from me. The real case that happened to one of my real friend who's working on a freelance as a designer, and he's combining the freelance with selling design on the stocks and marketplaces. So while creating the design for order from the freelance, he had some sketches that he saved, but he didn't use them in his project. And later on, he decided to use these sketches, make them real for other projects. Can we count this as illegal actions? Because actually he already sold the project in the same style, in the same colors, and later on he's going to sell them, but a bit different. I hope you got my question.
Yeah, I got you. Actually, it's hard to answer you from this point of view because we should take into account really a lot of connected issues. For example, what is the terms of his license agreements between himself and his client, his first client. So it could be the non-exclusive license, and in this case, it's like everything's okay. It could be the exclusive license, but for just the final result, it could be the exclusive rights for final results and all stages of creation. So he could even sell that sketches. So it really depends on the terms of license. Second thing is the measure of differences. I mean, how the second product, what is the difference between second project and the first one? Because, yeah, it could be quite the same stuff, but in some cases it could call style. I mean, and he could find new customers because of his style, and all the new ones wanna take his works because he did it in special way, use special things. For example, he creating special colors, and that won't be a violation because that's his style and all his projects are made in this field. So yeah, I would look to his license terms and to the differences between the old work and the first one and the new one. So if there are no big differences, it could be a matter of violation, because if he sell all the rights, for example, all the rights of use, exclusive license, and he can't use it by himself, and the new product is quite similar to the previous one, it could be a problem. But it's hard to say it without seeing these two projects.
Thank you. I will definitely ask him for checking this webinar too.
He definitely should be aware, should be careful, and maybe if he do this thing really often, he should modularize his license agreement. He should indicate that in that agreement that he could use the sketches, the references, which will not use, which weren't used in this particular project, in his next projects. I think for most clients that will be okay, and that will protect him from any future abuse.
Thank you. From my side, I see that our timeline and our webinar is going to be ended very soon. Before we will say goodbye, I would like to thank you for everyone who been with us this time watching our webinar. Hope you find it useful. Share it with your friends who are also designers, so everyone will be able to use that great tips that Arseny presented for us today. I welcome everyone to jump into the description after the webinar, check our checklist that was prepared. Also join our community on the Facebook if you haven't joined yet, and free to ask your questions in the comments section below in the Facebook post. I'm 100% sure that our managers, even after the webinar, will be glad to answer your questions in the direct messages or by the email. Arseny, I won't say goodbye to you because it was a really great time. I will definitely glad to see you in the future, maybe in the next year with one more great presentation for our designers to be ready to protect their rights. I guess, yep. Word to you.
It was a pleasure to speak with you and with your creators, vendors. So hope to see you again.
Yeah, thank you, Arsen. Thank you, everyone. Don't forget to subscribe and hit the like button below this webinar, and we see you in the nearest future. Bye bye.